Now, some of you may remember this case when it came down last summer, and it caused quite a bit of controversy and something of a shock to biotech patentees. Some retired judges, naming no names, have commented extrajudicially that they think that it was wrongly decided and the Supreme Court got it all wrong. But before we get to the reflections, we need to set the scene and spend a little bit of time talking about what was the case all about. So bear with me for a few minutes, those of you who are very familiar with it, and we'll bring everyone up to speed. So it concerned a transgenic mouse, the so-called Kymab, which had been developed by Kymab, defendant, which at the time was a relatively small Cambridge-based biotech company that had raised about $280 million to help with the development of, amongst other things, the Kymab. And the mouse was used to discover and develop biologics, so basically fully human therapeutic antibodies, monoclonal antibodies, and vaccines. The claimant was Regeneron, which, as everyone will know, NASDAQ listed, a real behemoth of the biotech scene, with a market cap of $56 billion, annual revenues of about $7 billion. And it had its own transgenic mouse for similar purposes, which it called the VelociMouse. So at the stage of the Court of Appeal, Kymab had lost. And as a result, it was facing an injunction against further use and further sale of its Kymab, an order for delivery up and for destruction of the mouse and for antibodies, and even for an order for disclosure of information in relation to products which had been developed by Kymab using the Kymab. All of those measures were stayed pending the result of the Supreme Court. And then when the decision came down, let's cut to the chase, put you all out of your suspense. Kymab won at the Supreme Court. It was a 4-1 decision, but it successfully invalidated the relevant Regeneron patents on the grounds of insufficiency. And the win swept away all the sanctions which had been contemplating following the Court of Appeal decision. And then 6 months later, happy days, Kymab was acquired by Sanofi for $1.1 billion, with a further $350 million on achieving certain milestones. So as you can see, there was a lot riding on it. And this was one of those very stark cases where the future of Kymab would have been a lot less promising had the Supreme Court decision gone against them. But it is, I think, fair to ask, has it come at a wider cost to biotech patentees? Okay, so sufficiency, just going back to some basic principles, one of those areas of patent law where many questions tend to lead back to public policy on why patents are justified in the first place. And this case is a really good example of that. And the policy, which is often called the patent bargain, is basically this, that in exchange for a period of exclusivity, the patentee should disclose sufficient information to the public such that the invention can inform the public for the wider benefit of society. And this plays out in a number of ways, but 3 key ways are shown here on the slide. So the skilled person must be able to work the invention disclosed in the patent without undue burden. Skilled persons entitled to make trial and error experiments and use their common general knowledge to achieve that end. And the skilled person must also be able to work the invention across the full extent of the monopoly claimed. And those principles are all going to be relevant as we go on for the next couple of slides. There's also an established principle that disclosure of how to perform one embodiment of the invention is sufficient to support other embodiments which are covered by the claim, if the claim discloses a principle of general application, which will work in respect of all those embodiments across the claim. And this is where the Supreme Court decision in Regeneron and Kymab comes in. And this is really the heart of the decision. What is a general principle of application such that disclosure of a single embodiment will support a claim covering many embodiments? So those are the legal principles. We don't need any more law than that. What was the case all about? So there were 2 patents in suit, and they both had, well, there were both method claims and product claims under consideration. The Supreme Court ended up focusing on claim 1 of EP 163, and that was a product claim. So in the time that we've got available, we're going to simplify the technology grossly, and I hope people bear with me if they find that this simplification is too gross. But at a very high level, claim 1 claimed a transgenic mouse that produces hybrid antibodies. In other words, antibodies that contained both human variable regions, and those are the grey shaded areas on the diagram that you can see on this slide, which shows a typical antibody structure. And it had mouse constant regions, and so those are the white parts on the diagram. And further, the mouse has a so-called in situ replacement in the part of the mouse genome that codes for the variable region. And this was the so-called VDJ region in the heavy chain gene locus and the VJ region in the light chain gene locus. So those murine parts of the genome were replaced with the equivalent human regions, whilst the other parts of the mouse genome, and in particular the constant regions, were kept, they were retained. And this was called a reverse chimeric locus. Looking at some of the factual findings, either they were either admitted or this is the findings on the evidence. So the claim was construed by the court as covering a mouse with any degree of replacement. So i.e. any reverse chimeric locus was covered. So to explain this and unpack it in a bit more detail, a typical human heavy chain gene locus contains 125 V segments in the V region, so the variable region, and the claim covered a mouse with its V region replaced with any number of human V segments. So it could have been one human V segment or the full 125. So what that meant was the product claim in effect covered a range of products, a range of mice, where those mice had different degrees of replacement of murine genome for human genome. So what was clever about this invention? Really, the benefit that it brought, and the benefit of this so-called reverse chimeric locus, was that the mice that were produced using this technique didn't suffer from what was called immunological sickness. So prior art mice, before this invention was disclosed and adopted, would suffer from immunological sickness, which meant that they didn't produce antibodies particularly effectively, and they weren't healthy. And so these mice, with the benefit of this invention, their ability to produce antibodies wasn't in any way compromised. And this was a really significant inventive advance compared to the techniques of the prior art. And it was accepted by all the parties that all the mice in the range would have this benefit, this utility. The problem was that even allowing for common general knowledge techniques, at the priority date of the patent, only a very small part of this range of mice could be made. I think the evidence showed that due to limitations on the techniques of incorporating gene sequences, I think you could only get between 2 and 6 human V segments inserted into the mouse genome, and there were no techniques available at the time that would have allowed all 125 V segments, or going beyond that to think about the J and the D, the entire human variable region. There were just no techniques that could have transposed that quantity of genetic material into the mouse genome. And this was important because the larger or the more of the human variable region that's inserted into the mouse genome, then the better the mouse works as a platform for antibody generation. The variety of antibodies it's capable of generating is much wider. So, but the Court of Appeal wasn't troubled by this problem that some of the mice in the range couldn't be made as of the priority date. It said that the benefit, this benefit of freedom from immunological sickness, was a principle of general application, and that all mice in the range would have this benefit and utility as they came, as techniques advanced and it was possible to make them. And on that basis, it found that the Regeneron patents weren't valid, they weren't insufficient, and they were infringed by the Kymab. In the Supreme Court, things were quite different. So Lord Briggs led the judgment of the court, and he extensively reviewed the relevant authorities. This seems to have skipped back. Can people still see the slides? Just checking.
Yeah, we've got Lord Briggs on the screen, Adrian.
Yeah, that's fine. So he reviewed all the authorities and he reiterated the requirement of sufficiency, referring to Article 83 of the European Patent Convention, and he said that it exists to ensure that the extent of the monopoly conferred by the patent corresponds with the extent of the contribution of the invention to the art. And this is a really key point. And he goes on to say that in the case, and this is on the slide, in the case of a product claim, the contribution to the art is the product which is enabled to be made by the disclosure, not the invention. So the inventive concept, which the Court of Appeal had identified as being freedom from immunological sickness, was not the contribution to the art. The contribution to the art were the mice themselves. And the court went on to say patents are about products and processes, not pure ideas. And so the flaw that the court identified in the Court of Appeal's judgment was that it would have upheld a monopoly for manufacture and exploitation of a product where the disclosure in the patent coupled with a common general knowledge would not have enabled a skilled person to make such a mouse at all. And the Supreme Court went on to say that the ability of both Regeneron on the one hand and Kymab on the other to make such a mouse actually depended on further and different inventions separately made by each of them some years after the priority date. So in short, the Supreme Court was reiterating in Regeneron and Kymab in the context of a class claim to transgenic mice that the basic patent bargain, a patent cannot claim products that it doesn't tell you how to make. So now we get to the reflections. Let's see to work out. Here we go. So first of all, this was obviously not a particularly welcome decision for many people because it invalidates patent claims on what look like a good technology. And you can see that this insight that Regeneron had about the reverse chimeric locus would have motivated and incentivized people to work in this field and find ways of transposing larger quantities of the human variable region genome into the mouse genome in order to produce mice who are both immunologically, well, free from immunological sickness and also a good platform for producing a wide variety of antibodies. So that was, I think, the cause of the dismay. But on closer study, it also provides clarity on some issues in English law that have been a bit unclear. So if we think first about reach-through claims, so in English law, it's generally thought, but hasn't been to date particularly well articulated, that a patent mustn't extend, in other words, it mustn't reach through to claim the results of applying a particular technical contribution that the patent makes to the art. So an example of this would be a research tool, such as a protein microarray. If that patent claims functionally defined compounds that would be found as a result of using that research tool, then the general feeling has been that those claims would be invalid as insufficient. But there hasn't really been any particularly clear authority on that point in English law. And really, this issue of reach-through claims in research tool patents is reducible to the division of between inventive concept on the one hand and technical contribution on the other, which has been outlined in the Regeneron against Kymab case. In this case, a reach-through claim, although it may claim compounds that can be derived using an inventive method and the insights of the research tool, it doesn't actually teach you how to make those particular products, and therefore the claims to those products cannot be sufficient. And so this case, I think, gives a legal basis to that chain of argument, that sort of chain of thought that has been around for a while in relation to research tool patents. Second question is what does this decision mean for whether future products or processes, i.e. products or processes which didn't exist at the priority date and couldn't have been made at the priority date without further invention? These are often referred to as inventive improvements or inventive infringements. Is it still possible for those to infringe? If it's not, then this would be quite a radical change to the law. And we think the answer is yes. It depends on a number of factors, not least, I guess, the specific nature, the drafting of the claims, and the level of generality of features. So if we take a really simple and hypothetical example in a not biotech field, if you imagine a claim to a bicycle, which is drafted simply to claim a vehicle with two-spoked wheels, a seat, handlebars, and driven by a person using pedals. So assume this patent was filed in the 1870s, the only embodiment disclosed was a penny farthing. So would that product claim be sufficient? We think the answer is yes, because within the terms of the claim, each of those features is supported by that embodiment. But if you then consider a person who comes along subsequently and invents, say, a suspension system for a bicycle, could that person avoid infringement by claiming that the patent doesn't disclose how to make a bicycle with suspension? And on that basis, the claim is insufficient and hence invalid. We don't think that sort of argument would work, because we think that would be to divide the product claim into a range denominated by what and this is to use the language of the Supreme Court, a wholly irrelevant factor judged on the terms of the patent disclosure itself. The problem for Regeneron was that the division of the product claim into mice with a small degree of replacement and mice with a large degree of replacement, that wasn't a wholly irrelevant factor. That was a very pertinent factor judged according to the language and the level of abstraction at which the patent is drafted. But you can see that this is the point where there will be quite a lot of argument. So moving on, what could Regeneron have done? This is a question for the patent attorneys amongst us. How should the claim have been drafted? And I mean, I guess one obvious comment is it needed to be limited in an appropriate way to what could have been actually achieved at the priority date. So it should have contained some limitations as to the degree of replacement of human genetic material into the mouse genome, to the techniques which were then appropriate. And clearly there could then have been further claims. Maybe there would have been dependent claims drafted with those limitations with a wider initial claim. So at least Regeneron would have had fallback claims, claims it could have fallen back on. Of course, the problem is that those claims wouldn't have covered the Chi mouse. So Regeneron was really driven into relying on the broad claims. And as I've said, it's not quite as harsh on Regeneron as it perhaps sounds, because they could have filed subsequent patents as technology improved on related aspects of the technology, such as selection patents. And as I said, the problem really arose because it was trying to stop Kymab, and therefore had to rely on some of its broad claims. And then the final point is, in the press release that came out from the Supreme Court, which accompanied the decision, the court said that the decision rebalanced patent law. And it said, referring to the Court of Appeal's analysis, and I quote, "The Court of Appeal watered down the sufficiency requirement, which is a bedrock of patent law, tilting the balance of patent law in favor of patentees and against the public." So there is an element of rebalancing, but this is probably not a rebalancing of a change of a long-standing principle. I think the view is that the Court of Appeal did misapply a key principle and was pushing the law to be more favorable to patentees, particularly in a biotech context. And what the Supreme Court did was rein it back. So I don't think the Supreme Court viewed that it was changing the law. I think it thought it was just restoring what the law had always been. Nevertheless, though, I think in conclusion, the decision will worry a lot of patent owners, particularly in the biotech space. And it emphasizes the perennial applicant's dilemma, which we've seen in Warner-Lambert from a plausibility point of view, and we see in this case from an insufficiency point of view. When should you file? When do you have enough experimental evidence, or when has the technology advanced enough to file to support and justify a claim of the breadth that you want?